I welcome everyone to the September 26, 2022 Planning Board meeting in Grafton. Pursuant to Chapter 20 of the Acts of 2021, this meeting of the Grafton Planning Board is being conducted with both in-person and remote participation by board members and members of the public. Remote participation by the public for the public comment agenda item, the public hearings, and any other matter for which the board allows public participation will be via the Zoom raise hand feature or in person. If you raise your hand on Zoom, you will be enabled at an appropriate point to enter the meeting via voice or video to make a comment or ask a question. In all cases, whether in person or remote, please identify yourself by name and address for the record. Every vote tonight will be taken by roll call. Please note that this meeting is being recorded as well as being broadcast live on the Grafton Community Television Government Channel. I'll open with a roll call of the board. Mr. Robbins.
Present.
Mr. Hassinger.
I'm here.
Ms. Hassinger.
Present.
Mr. Venkatraman.
I'm here.
And I am here, obviously. And staff present is Chris McGoldrick.
Here.
And Natalia Alward.
Present.
Associate member.
And associate member Maura McCormack is here.
Present.
Thanks. All right, our first item on our agenda tonight is public input. If any member of the public has something to discuss with the board that's not otherwise on the agenda, now would be the time to raise your hand in Zoom or in the room. Seeing nothing, our next agenda item is an action item for Grafton Land Trust Trail and Drainage for Stillwater Estates, 11 Wheeler Road. This is continued from our last meeting of September 12th. What do we have, Chris?
Yep. So for this, we've updated the correspondence that we've received. Have not yet heard back from Graves. I did discuss with them, as was hashed out at the previous meeting, that with some of the more rain events that the board would like to have some review of the site and the operation of the drainage that's been put in place currently. I did receive email correspondence from town council regarding the issue, which I can read for the benefit of the board. Her statement is that, "Hi Chris, thanks. I agree that the board should not involve itself in title disputed, i.e. rights easements over Grafton Land Trust property. If the information in the letter is accurate, I think the issue for the board are correcting language in its previous decisions, conditions, which it can do, and perhaps questions regarding its ability to enforce conditions in the special permit." And then offers, if needs to discuss further, that we can. So those are the updates that I have. The board did ask to have this placed as an action item ongoing as they review it, which we have done for tonight.
Any members of the board have any further questions or comments on this?
This is probably the point that we made at the last meeting. The question for the board is whether there is any action that the board ought to be taken, and I think the potential for the action might be, as I think the email from council suggested, any action that the board might take in terms of enforcing the conditions of the decision or modifying the decision if the board concludes that the conditions turn out to be inadequate to achieve the desired result. But I think a lot of that hinges on Graves' evaluation of the situation.
Do we have anybody there in the room that wants to, or here on Zoom, that wants to say anything about this?
That was where I was going next. I was giving the board a chance to...
Yeah, there's no attendees in the room. I do note that there is a presence in the room, not on Zoom, but that's the discretion of the chair to recognize them if they see.
Does anyone want to speak on this that's not already in our letters that have already been sent? Anything new or further comments?
Mr. Chairman, good evening, members of the board. My name is Mike Sawarda, live at 32 Barbara Jean Street in Grafton, and I'm here as an attorney representing the Grafton Land Trust. First, I want to apologize, your last meeting, I know Attorney Napick appeared at the meeting. Given the lateness of it, I had a conflicting appointment, so my apologies for not appearing. I did come down from Maine today to make sure I made it tonight. I had a little leak up in a cottage up there that we were trying to attend to. I did want to address, if I could, council's opinion as to not getting involved in private matters. I would concur with that. I don't think we're asking you to get involved in negotiating an easement with the developer. However, it's certainly within your purview, given your part of your responsibility as a board is to make sure that drainage on a project does not impair abutting properties and that it's handled properly. Whether there is an absence of that easement, in fact, is a factor that I think you can take. I don't think you should get into negotiating an individual easement with the developer in Grafton Land Trust. But the absence of that easement does not, in my opinion, give them a right to actually implement the plan that you approved, because they don't have a right to go on our property. I think secondly, just as far as the oversight matters, the board did reserve wide oversight matters in this with a specific condition, and they're talking about continued oversight with regard to the Grafton Land Trust Trail. We've certainly, in the storms that we've had recently, it has been completely impassable. And we would hope that, given an example, we've got a hurricane that probably is going to come up the East Coast and again dump volumes of water on the property. Anything that we can do to help you expedite your decisions, please let us know. If you need Mr. Hill here, who is an engineer, we'd be happy to have him come to a subsequent meeting. When Graves' results come in. We've tried to work cooperatively with Mr. Napick's client. We'd like to do that again. I think that's generally solutions get better if we don't involve you and we can work with them. And so I appreciate your time. Thank you. If you have any questions, I'm here to answer them.
Anyone have any questions? Go ahead, Bob.
Hi, Mike.
Hey, Bob.
Been a while.
A little bit.
You used to sit up there around where Dave is sitting when I came to the board.
Dave actually noted that when I came in tonight.
I'm concerned about this, and I think we should do what we can about it. I think that this power that you talk about is in what, 61W?
I believe that's correct. And you also have pretty broad oversight powers under the conditions you had in your permit.
Right. I really think, given the city's, we've got to get this thing moving. We can't just have it keep being a problem. So I'd like us to take whatever action we can to help it. I don't remember the board in my 30 plus years ever acting under 61W. And I don't know about quite changing something like you were saying. So I'm not absolutely sure exactly what motion I should make. I do agree with your private versus private matter versus something for us. As usual, I think you've got that pretty well in hand. So I'm looking for help from you or from Ginny or from Chris for an action item at the next meeting, if not something we could do tonight.
Well,
any suggestions?
Mr. Chairman, may I?
Go ahead.
Under Chapter 41, and it's Section 81, Bob, of Chapter 41, the board can, by its own motion, amend or rescind or revoke a subdivision approval. I think I speak for the Land Trust and a number of members here tonight. We really don't want to be confrontational. I would prefer that we not have to petition you or that you make a motion to revoke the entire subdivision. This is one thing we need to work on. I prefer with council to help to shape that remedy that we agree to, and if there's a modification needed to your plan, that we come and say, look, we sort of agreed on this, this sort of works for us, and either through your motion or we could, a joint petition to modify it. That would be preferable from our end. But I need a partner in that process. And we hope that maybe the board could encourage the developer to at least have discussions with us, in that regard.
And that's why I am interested in forming some sort of action we could take if we needed to at the next meeting, which hopefully would encourage the sides to get together and avoid the necessity for that.
Yeah, I think that's really in my mind, that's really kind of the key question is what modification of the plan would work here? Would be a step towards resolving the issues to the extent that this board has power over that. I mean, and yes, any individual agreements between the two parties, that's not our purview, but what I'm interested in, I think, is along with Bob, is identifying what it is, what would be a constructive modification, and how we go about getting that done. If the simplest path forward is for the board, as 81W says on its own motion, to modify their plan, the question is what is the modification that's going to work here?
Through the chair, if you would like us to develop a petition that you could specifically respond to or act on, I think we, as a land trust, we could certainly put something together. And if with a cooperative developer, I'd be happy to share it and see whether or not it's something we might work on together.
Yeah.
But if
Sounds like a plan to me.
yeah, if you want something so you don't have to shape it, that we at least shape it and put it before you to respond to, I'd be happy to do that.
That would be helpful for at least me. I don't.
I think, Chris, what can you say about?
What I was gonna say, I mean, I think largely the the engineering or the solution for this matter in terms of the what remedy, if any, the board can consider is largely going to come from collaboration between the developer and the Grafton Land Trust. It's not really the purview of the board to come up with design solutions for it, nor will Graves, I think, be amenable to trying to resolve that as their peer review in their peer review role. So I think what we could do is I could draft a letter encouraging the developer and the Grafton Land Trust to work towards that resolution, and that staff and the board would be amenable to whatever procedure needs to take place to implement that.
So the key question becomes, what modification to the board's approval would work here? And if we identify, and yes, if that's something that the two parties here can kind of largely work out as to, this is how the permit ought to be modified, or the definitive plan approval. This is how the approval should be modified to accomplish what everybody agrees needs to be accomplished. And then the path for actually the sort of the paperwork part of that, getting that modification issued by this board, I would simply look for what's the path of least effort involved. And off the top of my head, I'm guessing that maybe I'd have to sort of review from a procedure point of view, but off the top of my head, it sounds like for the board on its own initiative to update or to modify the decision might be the least the least amount of effort, because I mean we could look at sort of a typical modification of a decision which might have to go through a public hearing process, and there's whatever the procedural matters are. So just from a procedural perspective, whatever is easiest for everybody would work for me.
Okay.
Well, I want to maybe do two things. One, I agree. In the end, the only way this ends happily is if the two sides agree and they come with the changes we need in order to implement their agreement. But in the meantime, I would like to be prepared at our next meeting to vote to do the things Mike has spoken of. I think there's a waiver that should be rescinded, and there should be I don't know whether you say revoke the approval, but I was wondering if we could suspend the approval, do whatever is approval is right, and have those before us and able to act at whatever point we feel that you're not getting to where you need to get. You follow what I mean, Mike?
I do.
That's what I want.
And as a point of
We need a
information,
motion?
the board does have a meeting 1 week from tonight at which, if there is sort of a short-term action that ought to be taken in 1 week, the board could, per Bob's suggestion, is keep it on the agenda, and let's for the next meeting, let's determine what if any action the board ought to take immediately, essentially, or as near immediately as, to the extent that the word immediately applies in any sort of governmental process.
Yes.
Thank you very much.
You're welcome.
Are we done with this? Oh, no.
Nope.
Thank you, Mr. Chairman. I'll try to be brief. For the record, Rob Knappich, I represent Wright Realty Trust, the developer, and just in an effort to strike a positive tone, I don't doubt that the developer is open to some sort of amenable or mutually agreeable solution. I don't know what that is yet, but like any businessman, he's a practical person, so I'm sure he's interested in the path of least resistance. However, just, to somewhat reiterate what I've said and make the position clear, this really seems like a second bite at the apple. The record clearly reflects that the deliberations before this board and the Conservation Commission reflected a concern about drainage. There was exaction, a mitigation, or whatever you want to call it, of a donation to construct trail improvements. Whether that was done or not, I don't know. It really wasn't the prior applicant or the developer's responsibility, but now the claim seems to be that the drainage as constructed is causing damage. I don't know that it is. You haven't, I've looked at it. I don't see a silt on the land trust property. It is before the Conservation Commission. I assume you'd be glad to know that another board in town is looking at this, and arguably that's a board that's, more familiar with the intricacies of drainage. And I can tell you that communication with the Conservation Commission doesn't indicate any drastic need for immediate action. In fact, the agent's suggestion was that, yes, there could be some modifications to the outlet control structure during construction, or seeding all possible areas of exposed soil, or adding additional control measures to the site. But as she acknowledged, the means and methods of that are the developer's responsibility. In addition, as Mr. McGoldrick seemed to at least imply, if not state at the last meeting, his view of it, I think, is properly characterized as something that didn't require some sort of drastic immediate measure like rescinding the approval of the subdivision. So yes, we're amenable to working through some reasonable response and something that mitigates any sort of impact to the property. But remember that, the drainage system was reviewed, analyzed by Graves Engineering. As I read the drainage report, when it's functioning, fully functioning, and it is, during construction, admittedly, there may be some de minimis, siltation that gets through. Again, I don't see it going onto the land trust property presently. But when it's functioning, the drainage report, as I read it, bears out that the post-construction drainage, not only the rate of runoff toward the land trust property, but also the volume of runoff because of the infiltration that the drainage basin provides will be less than prior to development. So we're certainly agreeable to tweaking something during construction, but the solution seems to be, or the suggestion at least from some was, well, come onto the land trust property, raise the grade of the trail in the vicinity of the detention basin, and install a culvert underneath. Well, I'll conclude by saying that although that might be nice, that's a very expensive solution to a problem that is simply not of the developer's doing. The fact of the matter is, good, bad, or indifferent, I don't know how it came about, but it's a simple fact that the trail is constructed in a wetland. Therefore, by definition, it's going to be wet a certain amount of the time. In addition, like any such trail, through use, it's become essentially a rut. So some of the pictures you saw of siltation in the trail, I'm sure happened well before construction occurred here, just because it's a collection. So I guess my point is that I think the developer stopped short of solving the land trust problem. Preventing siltation from getting on the property, tweaking the design or the present infiltration, or rather sedimentation measures, sure. I'm sure the developer is for it. But if the demand is to solve a problem that's not of our doing or nothing, I don't think we're going to get far. But I'm willing to give it the old college try. Thank you very much.
Yeah, and I think that's the impression I get both from council's advice and some of the discussion here is that you guys basically, if you get together and you kind of reach some mutual understanding, and yes, I have no doubt that the advice of the Conservation Commission would be helpful in this regard too, as to that's their direct stormwater management is directly within their jurisdiction.
Okay.
In a sense, more than ours. But in the end, as we've discussed, I think if it comes to the point of their the conclusion being that the approved plans need modification, that's kind of that comes back here for the board in whatever way we determine to be most expeditious to see to it that modification gets approved by this board.
Okay.
But yeah, there's obviously still some negotiation to go on here between the parties involved.
That's right.
Bob?
Here's my problem. We went back and forth, around and around about this issue. We got to a point where it was my understanding, and I think maybe other boards members' understanding, that there was a satisfactory agreement between the land trust and the project on this point, and that they would be able to move forward, and that they would move forward and be satisfactory to the land trust. Now we don't seem to be there anymore. Something has changed. I don't know, but that's a reason. That's a reason that I think we need to step back from the approvals we gave in this area, because the expectations have not been realized, and we do not see yet a solution that will be satisfactory. That's why I say, great, go ahead, work on it, find a satisfactory solution. But in the meantime, the clock is ticking, the project's going forward. It's going to get harder and harder to do things. So I would like to have at hand, in case we need it, actions that we can take relative to the fact that it's not working out the way we approve.
Thanks, Bob.
Anybody else want to talk about this at this point, or can we move on to?
Go ahead, Chris.
Yeah, so I guess what I can propose is for the board's discussion at the next meeting is I can develop a letter essentially summarizing the discussion tonight and encouraging the two parties to work together. And I'll also outline the pertinent condition language that's in the decision that the board might want to consider for action. And I think those two will set the board up for success with managing this matter moving forward. And I think that's, I hope, responsive to Mr. Hassan.
That's good for our response, but Mike suggested perhaps helping to come up with the kind of language we need for what I'm talking about.
Understood.
Now, I'm not sure whether it's all going to happen in a week, but I would like to stay on top of it. And I'd like us to talk and know where we are next week. And we better have good feelings about what we hear.
I would agree. Right. Anyone else have anything further for this?
At this point, anything I said would be repetitive.
Yes. And I'm not seeing anything.
I try to avoid representing the interests of the Department of Redundancy Department. Not always successfully.
All right. So I will just say out loud that, as discussed, we're going to bring this back up with our discussion and potential action item for our next meeting next week. Thank you. We got 4 minutes. Does the board think we will do away with the bylaw update request for feedback in 4 minutes? Anything further
Yes.
to?
Yes.
All right. Does any member of the board have anything more to discuss or recommend to the bylaw update committee, I believe it was called?
Go ahead.
I was just gonna say I did take a quick look at the shade tree bylaw and the scenic road bylaw as from the previous. Those were the matters that the bylaw committee was looking to review. I don't have any issues per se in how the bylaws are written. I did note that, which I think we mentioned at the last meeting, but the scenic road permit, the board had expressed interest in looking at non-criminal disposition in terms of enforcement, finding that bylaw didn't have as much teeth as they had wanted for some of the matters that came up. So I think that's something that we can recommend. The other, with the shade tree bylaw, reading through that and refamiliarizing. Again, I don't think there's any issues with the shade tree bylaw per se as written, but I noticed that there's in the language it talks about applying for the Shade Tree USA certification, which we're no longer a party to, and some of the procedures. There's a tree advisory committee, and I'm not sure
That has not existed for quite some time.
how active that is. So I think in terms of those kinds of procedures, more so than the bylaw itself, but we may want to look at our procedures and either amend the bylaw to have and our procedures to be more conducive to current operations, or if we want to reinvigorate those procedures as outlined in certifications. But those are my comments for that.
And I think all those issues are on the radar already of the bylaw study committee. If nothing else, I know I've made notes on those items, and I think someone else has commented on the shade tree committee question. So yes, there are some aspects of that the committee is aware of already. That planning to do some investigation, and we will be, as work proceeds. Right now, the bylaw study committee is collecting suggestions from various stakeholders as to here's some things that may need to be looked at. We're not asking anybody at this point to propose solutions, but the committee will be, after gathering up all these suggestions, the committee will be working on proposed changes to the bylaws, and that will involve subsequent interaction with, like, the planning board or every other. So this is the first step in the committee's trying to identify all the issues. Then the committee will do some further investigation and study and begin working on proposed updates to the bylaws, and we will be circling back with all of the interested parties regarding the proposed updates, because we're not just going to go and blindly propose an update and say here's what it is, take it or leave it. Trying to get something that works for everybody.
Okay. A couple of things. Since our last meeting, we've had a chance to have some experience with town-owned trees within the right-of-way. Again, ripping our power and internet off the house when they fell. Reminds me that that we did very nicely at getting the town happened to have people in town to deal with the trees the next day, and they did a good job of dealing with dead trees within the right of way, which there are several of here. But that reminds me, in the past, I've had concerns that the scenic road bylaw seemed to say any tree, and not distinguishing trees that needed some sort of pruning or
which is way dead.
or dead trees. And the way it read the last time we dealt with it, or I dealt with it, it sort of said anything you want to do to a tree that's within the subject area, basically the right of way, you have to have a scenic road permit for. We've had some of the town tree folk push back that no, they can do what they need in terms of maintenance of that sort. And I just, it'd be good, it'd make me happier anyway, if we were sure that everybody, the law said what everybody thinks it should and maybe thinks it allows already. That's just a small thing. There's also one totally unrelated thing, except that we have official public meetings. I haven't gone back and looked at whether we actually changed this, but I think it's in the bylaw, not the charter. There's a section about posting agendas and making changes or additions to agendas for meetings that date back to around the time of the charter being adopted. And at that time, the state didn't have any open meeting law. So that really was important from the town's point of view. Now we have the open meeting law, which more or less addresses the same subject, but the rules are a little different. And I wonder if the days that you count for the notice is one thing, and the other was what procedures we had to follow to add something to the agenda. At the moment, according to the bylaw, the town bylaw, the board has to vote to take up an emergency item and agree that it qualifies as an emergency item. So that ought to maybe be, checked and smoothed out so that whatever the state's procedure is, which isn't written down anywhere as far as I know, that just somebody, maybe the chairman, decides that there's an emergency item that's come up. If that's the way it is, then the bylaw ought to be different, or maybe we should have the bylaw to extend the rules beyond what the state requires. Anyway, a look at that. Okay.
Yep, that's a topic the committee can take into consideration, can study, recommend any relevant updates. The committee is looking for the bylaw study committee who would be looking for sort of a written response from the board. So, yeah, while as a member of the bylaw study committee, I'm obviously aware of what the board has just been discussing. It would be good to have that, sort of summarized in writing and sent to the entire bylaw study committee, so we have a written record of it. That's what we're looking for from everybody. We've sent out, I think we've sent out requests to something like 27 different departments, boards, and committees for feedback, suggestions on various elements of the bylaw. So I think we've gotten about maybe either 4 or 6 back so far. The deadline was October 14th, so if the board wants to take this up at next week's meeting for any further thoughts, that would be consistent with the bylaw study committee's schedule.
And I can draft a letter between now and then for the board to consider, and if they want to add or modify that in any way.
Sounds great.
And just for the record, the bylaw study committee is more than happy to accept input from the public. Any suggestions? Not limit, and we're not limited to, well, either tell us by October 14th or we'll ignore you. That's not the way it's going to work. We're going to remain open for suggestions and comments throughout the process. The bylaw study committee does have its own page on the town website under the name of Boards and Committees, Bylaw Study Committee, surprisingly. And on that page, there is a clickable link to email the committee. That's the quickest way, the easiest way for the public to send a comment to the committee. So this is not so much, I mean, every member of this board is certainly welcome to comment as individuals. If anybody from the general public happens to be watching this meeting, that's my way of the bylaw study committee asking for the public's input. We will be publicizing it in a lot of other ways too.
Sounds good. I think, as Chris said, we'll get the letter to send off ready for our next meeting.
Well, that took more than 4 minutes.
Yes, it did take more than 4 minutes. But seeing how the time is 7:30, we should probably get into our public hearings. The first of which is zoning articles fall town meeting warrant, which is a new public hearing.
Oh dear, I suppose that means I could read said legal notice. Pursuant to Mass General Law, Chapter 48, Section 5, the Grafton Planning Board will hold a public hearing on Monday, September 26, 2022, commencing at 7:30 p.m. in Conference Room A at the Grafton Memorial Municipal Center, 30 Providence Road, Grafton, Mass. The purpose of the public hearing is to provide interested parties the opportunity to comment on proposed amendments to the Grafton zoning bylaw, which have been submitted to the 2022 Fall Annual Town Meeting warrant as follows. Amend Section 5.10 entitled Medical Marijuana and Marijuana Establishments, and Section 3.2.3.1 entitled Use Regulation Schedule, for the purpose of alignment with changes to the Cannabis Control Commission regulations since the section was last updated in May 2018, including provisions for home delivery operations, the merger of medical and adult use marijuana regulations, and revision and reformatting of the existing language. Amend Section 3.2.3.1 entitled Use Regulation Schedule for the purpose of allowing mixed-use via special permit and site plan review from the Grafton Planning Board in the neighborhood business and commercial business zoning districts. Amend Section 4.2.1 entitled Off-Street Parking and Loading General to exclude structures and uses within the Grafton Common Historic District from off-street parking requirements. A complete copy of the text of the proposed amendments to the Grafton zoning bylaw is on file with the town clerk and the planning board office in the Grafton Municipal Center and is available for inspection during normal business hours. Individuals requiring special accommodations at the public hearing should contact the planning board office at 508-839-5335, extension 1120. And with that practically described the proposed zoning amendments.
Yes. And I'll take this public hearing a little bit differently than our normal, where the board has had many meetings to discuss these proposed changes. I'm going to open it up with the public before the board talks anymore. Is any member of the public, either on Zoom or in the room, wish to talk to, ask questions about, or discuss in any way these zoning article changes?
We see no attendees
I
on Zoom.
see one person in the room. Come on up.
Come here.
You could sit, you could stand, whichever
Your
you like.
choice.
Just state your name and address for the record.
My name's Judith Danko. I live in Worcester, Massachusetts, but my husband and I own a property in Grafton.
Right.
in the neighborhood business zone, and I've worked with Chris and even been before this board. We are just here to support the mixed-use proposal. We feel that it would really help the property owners to get better use out of their property and even create a better environment for the neighborhood. It is currently mixed use and mostly residential, so I don't think there's any conflict there, but we just are here to support that change.
Well, thank you.
Okay.
Thank you.
Thank you. It's the dentist. That's the dentist.
I'm not seeing any other hands in the room or on Zoom. Does any member of the board have anything further to talk about regarding these articles?
I am interested in whether we ever heard anything from the Historic District Commission.
Yep, I attended a Historic District Commission meeting and discussed that article with them in relation to the exemption of parking. Generally, I don't want to speak directly for them. There was no formal correspondence, but at the meeting, I got the impression from the discussion with the Historic District Committee that they are generally supportive of it. I think the one concern that was raised was in relation to the types of mixed use that might be located in the property if they were more intensive and required additional parking. I think that's something that the board would consider under their normal regulatory in terms of a use going into a property, but certainly a concern to be noting of, even though the requirement for parking would be excluded. Certainly something that the board will want to consider in their normal site plan or special permit review procedures.
All right. Hearing.
Shall I move to close the hearing?
I have a motion. Do I have a second?
Second.
I have a motion and a second to close the public hearing. Mr. Robbins,
Aye.
Mr. Hassinger,
Aye.
Ms. Hassinger,
Aye.
Mr. Venkatraman,
Aye.
and I vote aye. I declare the public hearing closed.
And I would move that the board vote to recommend passage of these three articles and to prepare the required planning board report for presentation at town meeting.
Second.
I have a motion and a second. Do I have any discussion on the motion? Hearing none. Mr. Robbins,
Aye.
Mr. Hassinger,
Aye.
Ms. Hassinger,
Aye.
Mr. Venkatraman,
Aye.
and I vote aye. I declare the motion carried unanimously. And my only further question and thought on this is, I heard at the CPC meeting this past Thursday that Finance Committee was looking to have their discussions on the warrant articles as a hearing that they were going to have planning board on their Wednesday agenda.
Yes.
Is that, do we have, are you planning on attending? What's the, okay.
Yes, I will.
Should have that in my calendar.
I will attend if I'm able, but I have another meeting scheduled for that evening, which, depending how it goes, may be a fairly short meeting.
All right.
So, although I'm tied up from 7 o'clock to sometime, I will attempt to show up at the FinCom hearing whenever I can, when I can. But
Yeah.
whether the FinCom will have any more questions than the select board had last week, which was basically none.
Yep.
I do plan to attend, so
Okay.
be happy to answer any questions that they need.
All right. So our next agenda item is another public hearing, not a continuation, I apologize. A determination of completeness, Highfields of Grafton from McGill Associates.
So, pursuant to section 3.3.12.3B of the Town of Grafton Subdivision Rules and Regulations, the Planning Board will hold a public meeting on Monday, September 26, 2022, commencing at 7:30 p.m. in Conference Room A at the Grafton Memorial Municipal Center, 30 Providence Road, to consider the final inspection for McGill Drive, Station 0+00 to Station 46+74.92, Silver Spruce Drive, Station 200+00 to Station 203+55.04, and Manor Hill Drive, Station 48+49.15 to 49+44, as laid out by the Highfields of Grafton subdivision. A copy of the application/plan is available for public inspection at the Planning Department and/or the Office of the Town Clerk during regular business hours. Any person seeking information or wishing to issue comments on this consideration should contact the Grafton Planning Department at 508-839-1400.
Alright.
Odd number, but I didn't know we had that number.
Like to lead us in, Chris?
So this is the determination and completeness public meeting for the Highfields subdivision. As the board may recall, we were targeting the October town meeting for this matter. My understanding is there was unfortunately an issue with the signatures for the citizens petition, so we will be missing the October town meeting for final road acceptance. However, I did confirm with the developer's attorney that and would agree that and encourage rather that we proceed with the process as the developer is largely through all of the hurdles needed for the determination and completeness process. That'll set us up well in advance of spring town meeting, but that would be the new target. Certainly we now have timeline if the board wants to consider additional information. I believe conservation is wrapping up a few other matters in relation to this subdivision, so we certainly have the time to proceed without rushing through the process at this point, but I'd encourage that we move forward as needed to get it wrapped up, so it's just the spring procedural matter that's needed.
Yeah, from our perspective, what's left to be done, other than the mechanics of getting it onto the town meeting? Have from the planning board's perspective, are we waiting for anything?
Yeah, so I think there's still the conservation matter that would be pertinent to review and let that proceed and finish up. They'll then provide us with the recommendation for that.
Because I think from our perspective, we want everything else. We want to know that everything else, all of the other departments, boards, commissions, etc., have all signed off on this.
Yep.
So
are we saying we don't take action tonight? We wait for those things?
Yes, I believe that would be my recommendation. That there's still some items to be brought forward, but largely the matter is that we have the as-built review from Graves that it came back favorably. So a lot of the mitigation procedures, there was the milling and top coating that was redone from the recommendation of DPW, and that has been completed. So the project is largely complete. I think conservation is the major item that's left.
Yeah, so I think that's what I want to come out of this with tonight is just let's identify what remains to be done.
Yep.
With an eye towards making sure that it does get done.
Thank you. And we can certainly help with that. Hello again, Rob Knappich on behalf of McGill Associates. So I think Mr. McGoldrick summarized it quite well. Notwithstanding our efforts, unfortunately, there was a procedural defect with the form of the petition. And so for that reason, either the article will not appear on the warrant, or I don't know what the status is. If the warrant has been published as we represented to you, then, and it does appear on the warrant, then we would or somebody with the ability to do so would request the town pass over the article. So action won't be taken at the fall town meeting. But if the board is so willing, as I discussed with Mr. McGoldrick today, that the developer's preference would be to proceed with the certificate of completeness process, but clearly on a more sort of relaxed time frame. And to that end, the outstanding issues with the Conservation Commission are finalization of the form of conservation restriction that the developer agreed to impose on the open space. I had a good conversation with town council, pursuant to which I think we're very close. And we're also awaiting the Conservation Commission's issuance of certificates of compliance or closing out of a few of the notices of intent. As you might imagine, for a project of this size, there were, I think, upwards of 6 or 8 notices of intent. So although we had expected and hoped that that would have happened by town meeting, now, it may or may not. I don't think that the board needs to take any action this evening. I don't know what sort of time frames are imposed by your bylaws or otherwise for taking action once our application is submitted. I don't think there are any, but presumably with the developer's consent or even request, you'd simply continue this matter as necessary for us to provide the information to you.
Just to say
Yeah.
out loud. Go ahead, Bob. Bob, you can go ahead.
Oh, yeah, I just wanted to be sure that we don't, that's like, Springtown meetings, something like, 8 months away. And I think that's where we would end up. And I'm just not, there's things like 6-month deadlines for certain, I don't think it's this, but for things like this, I want to be sure that we're not, delaying it unnecessarily or in a way that could cause a problem. You know what I mean. Yeah, and so I don't know whether we should no, this is a what deadlines do apply? We know for special permit, but I'm not sure what deadlines apply for this. Whether just, I don't know, tabling.
Let me just look up to double check.
I will say I don't think we can just table it where this is a public hearing. It would need to be continued to a time and date certain. My understanding.
I think that's right.
Right.
Probably so.
Yeah, let me double check. I don't believe that there's any decision deadline for the board to be cognizant of in this matter, other than continuing to a time and date certain. But let me just take another look.
I think it's correct to say that the certificate of completeness process is not one that's set by statute, like the process of a definitive subdivision approval or a special permit. So for that reason, I don't think any particular deadlines apply. The only deadline we were working toward, and the one that we're grateful to you for sort of relaxing, is that it was supposed to be done in advance of the warrant being closed, but you agreed that we would sort of clean up these loose ends even after the warrant was closed. So the deadline it's not so much a deadline to complete this process, but there really was, and it was by the time the warrant is published. So assuming that same deadline would apply to the Springtown meeting, then we're really on a fairly relaxed time frame. And to Mr. Hassinger's point, if I may, take the liberty of stating it a little bit differently, it seems that the concern, and it's a legitimate one, and one that I thought of, is any action you take subject to sort of lapsing prior to the Springtown meeting. And I don't see that as the case either. I mean, in an extreme case, if you issued a certificate of determination of completeness and then the town meeting didn't accept the road for, a matter of years, then the concern might be, well, maybe that road isn't in the same condition or that sort of thing. But here, where there's been recent wholesale, there was the whole road, as I understand it, was paved. And as I think Mr. McGoldrick confirmed, Graves confirmed that it's in condition for the town to accept. Maybe, a simple confirmation of that come springtime is all that's necessary to protect the town against any sort of, delay between the certificate of completeness and actual taking of the road.
Yeah, I think in this case, there would be the, sort of the hypothetical concern that the road looked good in the fall, but over the winter, the condition of the road sort of, something happened. And then by spring, the town would say, we need some things fixed before we can accept it. I think I've heard, in the past there has been that has come up occasionally. This time around, seems unlikely, but yeah, I would recommend that we kind of just double check on any timing requirements and sequencing requirements. Just to make sure that nobody's wasting any time on this. I do know that the warrant for the fall town meeting was closed last week by the select board without this on it. At least the copy they had that they voted to close did not include the citizens petition.
Thank you. I did not know that. Thank you.
So how about if we put a pin someplace out far enough into next year, January, February, whatever, and ask to continue the hearing until then?
I'll say we don't have our approved schedule by us approving, basically, for our next year,
All right.
December.
Our last meeting in December then.
That would be December 12th.
I think that's fine.
Yep.
Sure.
Yeah, so we'll circle back by then and meet between now and then, we'll check timelines, schedules, anything that could conceivably affect how this process will play out. Make sure that we get every I dotted, every T crossed.
Okay, can I move to accept the forthcoming written request
I'm
from
going to
the applicant to continue this public meeting until December 12th?
I'll second.
All right, I have a motion and a second. Any discussion? I did see your hand, Chris. Did you have something to? Nope. Okay. Any discussion on this motion? Hearing none. Mr. Robbins.
Aye.
Mr. Hassinger.
Aye.
Ms. Hassinger.
Aye.
Mr. Venkatraman.
Aye.
And I vote aye. I declare the motion carried unanimously. We'll pick this back up in December.
Very good. Thank you. And I thank the town planner's office for their ongoing assistance with this. Thank you.
And just as one point of procedure, I'm sure you have thought about it already. Just follow this up with an email just to formally request a continuance because it is a public hearing.
I have a form here.
Okay.
Or use the form that he's gonna hand you.
Great.
To be picky, it's a public meeting and not a public hearing.
Public meeting. Thank you. Yes. All right. That brings us to our next discussion item, an update regarding 8 Millennium Drive, Jushi, Mass. Inc.
Yep. A letter was provided as correspondence in relation to this matter. I note that the applicant's attorney is available. I'll let them, if you want to give an update, or I can give a brief summary of our discussion, whichever you prefer.
You take it, Chris.
As I think is pretty clearly stated in the letter, for a number of reasons, the development as proposed has seen some challenges in coming to fruition. What is being proposed is that essentially the use for this property is going to be re-advertised, looking for other potential uses for the site outside of the marijuana use that was proposed, as well as still pursuing, if market conditions change, pursuing the development of the property as it was permitted. Largely, in discussion with the applicant, they want to be cognizant of the board's time and not continually request continuances, as there's still some question of what the final use of the property will be. So they're willing to allow the current application to lapse without further continuance. And we did discuss, and their understanding that then, if that does lapse and they come back, it will require a full application as before, and they're willing to meet that requirement. So.
Yep. As I recall, Jushi had expressed an intent to substantially redesign the project anyway. Mm-hmm. So the approaching it as an entirely new application as opposed to a modification is probably not as great a difference as it might be if it was just mostly the same. Mm. But in either case, now you guys have the flexibility to, you don't feel like you're under the gun to get anything done, but you have the flexibility to continue to pursue development of the project in a manner that suits the Jushi, or ultimately, if it suits the Jushi to sell the property to someone else, then you'll take it from there.
That's right. And Mr. Chair, members of the board, good evening. Just for the record, my name is Joshua Lee Smith. I'm outside counsel for Jushi. Chris gave a really good overview of what was set forth in the letter that I submitted to the board as well. I had also submitted the same letter to the select board because, as you may recall, it was about a year ago this time. It was September of 2021 when I was before the board along with, I think Bob Carr was with me, who is an old friend of the town. Back in 2017, I'm reminded here as I'm looking at the agenda, this goes back to 2017, as well as representatives from Jushi at the time. And I hope that folks can appreciate that we did come to the board in good faith. Jushi and Nature's Remedy were two very excited parties looking to sort of pass the baton on to Jushi, obviously a much larger company, a company that is a multi-state operator, very successful in many different states, and has now has interests in Massachusetts. This was a purchase by the company of the stock of Nature's Remedy, and along with that came a number of different assets, all of which were already up and running in operation in some form or fashion, including retail, cultivation, manufacturing. This was the only site where it was at a different stage, obviously. And as you point out through the chair, Mr. Robbins, there was a contemplation that to the extent that this was going to go forward, and Jushi had every intent to go forward, that the project would ultimately look a little different in terms of the layout, scope, design. But they wanted to preserve that special permit because Nature's Remedy, there's value in that. They were paying for that. And so I'm here tonight to, be the bearer of bad news officially. It's unfortunate. It's disappointing. Again, we know it goes back to 2017. I was not there at the very beginning with Bob Carr in those early discussions with the town, but I know that there was a lot of time and effort that went into it. I was sort of on the tail end of some of those Nature's Remedy extensions, and then finally the handoff to Jushi. So it's disappointing for me as well. I'm a land use attorney, so I like to see projects get not only shovel ready, but actual shovels in the ground and turn dirt into, living, breathing vehicles for change and employment. And, there were a number of jobs that were contemplated to be created here. It's a great site, but it's also a great industrial park, office park as well. And I know that, I think from a positive standpoint, development is still pretty hot, at least in certain sectors. I've sort of shifted my focus over the past year. Has changed dramatically from doing a lot of the cannabis related permitting now to a lot of mixed use multifamily. There's been discussion about that, transit oriented, and I see that there's an MBTA matter that's going to be discussed. I'd be interested in hearing about that. This is the life we lead with respect to development and the ebbs and flows of the market, the economy, and we've got a global thing happening right now that everyone's aware of. So, with everything, it was in the aggregate that Jushi was not able to turn the corner here. We did make reference, and my client wanted to be open about it, and it's not difficult to find. If you Google Jushi, you can Google Jushi stock price, and you can Google MSO, looking up certain funds, stock funds, on the Canadian Stock Exchange. It's been a difficult ride, but it was exacerbated, the sort of negative effect with everything that's been happening. And I don't need to regurgitate that. I think everyone's feeling it in many, many different ways, but it's real. So with that, it's unfortunate. I'm disappointed. I know my clients are very disappointed, but they are certainly motivated to work with the town, to work with Chris, to work with. I had a brief correspondence with your town administrator, Evan Broussard, and I know I believe, is there still an economic development director?
There is.
And I know WBDC has a foothold and a lot of interest in this park. So, and I do know as well that there's some interest already from third parties. So I can't say whether it would be cannabis or non-cannabis. If I were to bet, I would probably think it might be a non-cannabis opportunity for the town. But I'm here to just express to you that the Jushi is definitely willing to and very interested in working with the town in getting the right operator there to build something that's going to work for everybody.
I will say, I believe I'm speaking for the board, but I'm they can tell me if I'm wrong, that it is very disappointing to hear this is not moving forward, but at the same time, I am very grateful for you coming, before us, explaining the situation, telling us that it's not moving forward the way you envisioned it, and letting the slaps. That's more than you needed to do, and it is appreciated.
No, I know the cannabis business has been from the outset. It has some unique challenges, shall we say? So, Nature's Remedy was basically the first one into Grafton applying for approval, and we've been kind of hoping all along, and I think we've all understood their position that there's only so much you can do at any one time, and this thing sort of played out. It was nice to see. I think we sort of I remember being pretty hopeful about the Jushi acquisition, and then that there was it seemed like an improved chance of getting that site developed. But as you know, yes, there have been a few things happening in the markets generally these days that probably affect the cannabis business, at least in certain elements, more so than some others. But I appreciate the challenges that Jushi is facing here, and again, as I said before the meeting, I appreciate you coming in and bringing us up to date on that, and we'll look forward to seeing what happens there in the future.
Absolutely. Yeah, I felt it was important to come in person, and it's always nice seeing you folks. So, as you had pointed out, although Jushi's not under the gun, they definitely do have an interest in seeing something happen here. They don't want to just continue to have it be sitting there, not doing anything. So whether they're going to partner with someone, sort of as a co-developer, or sell it off, or do something else, is yet to be seen. But they definitely have an interest to do something quickly. I can guarantee you that.
Yes, as we are aware, there are some properties in that general area that had some promise, but nothing is within sight at the moment in terms of actual development. So maintaining the prospect of development there in some form is looking good.
Go ahead, Bob.
A couple quick things. Are they the actual owners of the land now?
Yes.
Yes?
Yep.
And what becomes of the agreement that had been reached with the selectmen? They have to have whatever agreement or
The host community agreement.
Does that continue to be in effect in case you wanted to come back and use that possibility, or does that start over again if you were to come back with cannabis?
I'd have to look at the actual house community agreement language. I don't know if it lapses at any point, or if there's a point of renegotiation. But I can certainly look into that. But I don't know off the top of my head what's included in that.
But I was thinking that our guest might know.
I won't say that it's totally open-ended, but it certainly allowed for a little bit of runway, longer than the special permit. So the special permit, had we were to come back and seek another extension, we would have to have done that by now. We would be before you asking for the extension. Otherwise, the special permit would have lapsed, which I think is about to lapse. So, unlike the HCA I think has a little bit more runway and time left on it. I think we'll be talking with both Chris as well as the town administrator as to if they want to take any formal steps with respect to that HCA, or to leave it open as Jushi explores the potential for the site. Because if there is a viable cannabis operator, then the solution might be, to benefit not only Jushi and the potential new operator, but also the town, an amendment to that HCA as opposed to completely terminating it now.
The interesting, an interesting piece of that is this talk we hear about CCC changing some of the, or taking more control over those agreements, and whether you'd have the one you have now or whether you'd have that go around new under new rules. But we'll wait and see when the time comes. Okay.
I guess I'm hearing nothing further. Thank you for your time so much.
Thanks, everyone.
Thank you.
All right. Our next agenda item, MBTA zoning. I know that this is basically a continuation of the past conversations, and
Yep. Yeah. So this is an item we're continuing to keep on our agenda, especially the weekly MHP webinars that we've been attending. I had a conflict for this week's meeting, but I know that Dave was in attendance. We kind of discussed a little bit, and I believe you've put together a little presentation. Did you want to go into that, or?
Yeah, I can. I don't have anything. I didn't produce any slides or anything to describe it. But just very briefly, the MHP webinar last week was the topic was complete neighborhoods, and the focus there was in the context of MBT and multifamily zoning. It was really looking at how multifamily zoning, a relatively dense multifamily zoning, integrates well with, their term is complete neighborhoods, meaning the dwelling units, the multifamily units are in close proximity to other things that people need. Just a larger number of multifamily units relatively close together gives the residents there much more opportunity to interact with one another. Placing these in, within walking distance of everything that people need, shops, services, the advantages of everything being within walking distance, having access to transit. I mean, this is, the MBT zoning is all about, living within walking distance of transit stations. So there's, you can kind of picture sort of the idea of, a lot of residential units in relatively close proximity to shopping, to services, to public transit, and after going, and it's all. I mean, it's not difficult to see, the advantages of those sort of development arrangements. What's a bit challenging is to try to map those concepts onto Grafton, because the only transit we have in Grafton is a commuter rail station, and as I showed the picture last meeting about how little developable area there is around our station, to the point where it's little enough that we're basically allowed to put our zone anywhere, because we can't, for all practical purposes, we really can't put enough of it near the station to accomplish the goals of the zoning. So if you look at Grafton and try to look for opportunities to achieve some of the goals of this complete neighborhoods idea, there's really, you can't really point at any place in Grafton. I mean, if you look at where the service, retail and service oriented businesses are in Grafton, they're not clustered together anywhere. Our business development has been more linear in nature, along Worcester Street, North Main Street down South Grafton, Providence Road to some extent. Practically all of our consumer-oriented businesses are just laid out in a linear fashion and not clustered together in a way that if you drop a bunch of apartments in that area, they'll have a lot of walkability to distance. So the concepts that they described last week in the webinar about complete neighborhoods, at best it would be challenging to try to apply those concepts in a meaningful way to Grafton. So that's kind of the bottom line is I took away from that is that I don't know how much of that we can make work in Grafton. But it does get to some questions that we will eventually be facing about we have to create this zone somewhere, and where, if we can find a location that kind of makes sense, at least partly in terms of this complete neighborhoods idea, great. I mean, we've got the 8 Pine Street development, which fits that model pretty well in terms of access to transit and hopefully the retail component of that. So it kind of fits that model, but that's like 9 acres, and there's really not much adjacent to that would necessarily fit in. So that's sort of in brief. That's what we learned in that webinar last week. Some ideas that I will keep thinking, and we can all keep thinking about the extent to which we can find places in Grafton where some of those principles at least would be applicable. But so that was the other thing on that presentation that I showed you at the last meeting, basically what the final guidelines said about what where the developable area was. I've added just one additional slide to that, which I didn't have a chance to send that to you, Chris. So if I could share my screen, I can show you. It's just one additional slide, basically highlighting the important parts of the zoning that we're going to have to deal with when we start to work on planning out our zoning. And where did I put that? There it is. So, these are what we have to think about. Number one, and I think we kind of knew this, but I thought, I'd try to put this together as, these are, I think, the factors that we're going to need to pay attention to. First of all, the multifamily must be allowed as of right. We can't, they will allow us to include site plan approval, but they will not allow us to require it by special permit or any kind of zoning variance. The size of the zone, I think I mentioned it the last time, it still has to be at least 50 acres in total, but it can be in several parts. It doesn't have to be one 50-acre piece. At least one of the parts must be 25 contiguous acres. So, you can have several pieces, but at least one of them has to be at least 25 acres. And no part can be less than 5 acres. So you couldn't take a 2-acre parcel and include it in the zone. They'll say, yeah, it doesn't count. The allowable housing density still remains at 15 units per acre. It's been that way. They're working on a calculation based largely on dimensional and parking requirements. That they're promising us a spreadsheet that will be able to fill in some of the details of our zoning, and they will calculate the density based on that. They won't let you include in the density. They won't let you include most of what they call excluded land. The same things that they exclude from the computation of developable station area. they would exclude from your density calculation. So if you laid your zone on top of Tufts, for example, they wouldn't count that at all. And finally, they do address affordability, which was not addressed at all in the preliminary guidelines. But affordability, our zone could require up to 10% affordable. Not the more typical 20 or 25% that we like to use, unless part of our zone is a 40R, in which case they would allow us up to 20% affordable, because 20% is the minimum 40R affordable requirement. But unfortunately, they won't let you have a requirement for more than 25% affordable, which rules out our 40Rs, at least in North Grafton, the 8 Pine Street, because that requirement is 25% affordable. So that we will not be able to account that as part of our MBTA zone. That's a mild disappointment, but we have another 40R zone that's not yet been developed that we could consider for inclusion in our MBTA zone. We might have to modify the rules for that 40R zone, but it's at least a candidate for consideration. So that's basically it, just to try to summarize what seemed to me to be the important parts of this that we're going to have to consider as we plan out our multifamily zone. As I said before, we have until the end of 2024 to get this in place. So we have some time, we have some flexibility, but it's not too soon for us to at least begin thinking about where might the opportunities in Grafton be for this MBTA multifamily zone.
Just as a random thought I just had hearing about the maximum affordability requirement. If we change the zoning that includes 8 Pine Street, they're currently permitted to 25, but if we change it at a future town meeting or whatever, down to 20, would that make 8 Pine Street included?
It could. Yes, because one of the things that they emphasize about however we set up the zone we set up can include existing development. While they require us to create the zone, they don't require us to commit to any schedule of actual development. And they acknowledge that you may have some existing developments in this zone that might be there for a very long time. They just want to see that there's the sort of a theoretical or hypothetical potential that someday you could tear down what's there and build the multifamily units. So that consideration would say that, yes, we could change the rules for the North Grafton Transit Village Overlay District to reduce the affordability requirement down to 20%. Now, GSX is already developing it at 25%, and that's not going to change.
We're approved with and everything.
Yeah, those are the rules they were approved with. So yeah, that I think DHCD would accept that. Although DHCD also has to approve any change we make to the 40R. And that applies to both of the 40Rs we have in town, that if we change that zoning, that has to be approved by DHCD through their 40R program. So.
Yep, I see your hand up. Go ahead.
Okay. I think, given the what Dave started with tonight, that it should be complete community kind of thing, walkable to whatever transit and whatnot. Maybe the right thing to do is to develop an overlay that meets these requirements to lay over the current UPS site. It would have to do what UPS has been going, or was talking about doing, which is to have an entrance other than off the end of the industrial park road. Would have to have an entrance in Shrewsbury, so that it would be a road through. But that leave the underlying zoning there for what we've hoped to have. But UPS isn't going anywhere. unless Chris or somebody knows something about that in the near term, we could put this zone there and it would fit those criteria. I think there's more than 50 acres in Grafton, something like 90 acres, isn't it? And that might be one of the best solutions. Because I agree with Dave, and I've agreed with what his point since the beginning, that it just doesn't fit. We just don't have places in Grafton that are really going to fit this idea.
And
Well,
there's just
that's one crazy person's idea.
and just one comment Dave mentioned that doesn't really apply to the MBTA zoning as was my understanding is with it, but there is more public transit in Grafton than just the Boston Worcester transit line, which is we do have some WRTA bus stops in Grafton. It doesn't really
those
change
buses,
the MBTA zoning, but it's
you're talking about the bus route that comes through, right?
yes. There's a few stops that it does stop in Grafton. I forget where offhand, but
I wouldn't count on that staying the way it is forever.
no, and it doesn't affect the MBTA zoning anyways. It was a commentary that there is more transit.
No, but it's they said complete community that's got a bus. I don't think the buses are making a big dent in anything though, and they don't go through areas that are really potent areas for this zoning. I think having a train station, which if you do, actually, once you get the development that's already happening across from the station, and then maybe you have this, you'd have a possibility. I think you'd be beginning to have a much stronger case for having a WRTA bus, a real bus, come to the station. So anyway, think about the UPS property.
Yeah, so I think the UPS property is definitely something that we're gonna want to look at, in terms of other locations in town, and to that point, I think what I could develop. I don't know if I'd have it ready for, this coming week, but I can try to put together an overlay map just for the board to take a look at that has the bus routes, the WRTA bus routes on it, as well as amenities that are described in that, such as proximity to parks and things like that. And that might help, having a town-wide map of that while we look at, what areas might this really be conducive for, in addition to the UPS or, as opposed to the UPS. And that'll help, I think, inform our discussion a little bit more, and maybe even by to Mr. Hassinger's point of looking at the WRTA route, as we look at places to put this zoning, we can also look at how that would fit with the existing bus route. Maybe there's modifications that we can propose that if these are developed, the WRTA can modify their route to serve these locations as well. Because certainly the walkability of the UPS site to something like the MBTA station, even though it's fairly close, it certainly wouldn't be walkable under the existing conditions. So maybe they're kind of ways that we can look at some of that kind of.
Yeah, apropos of almost nothing, speaking of walkability, someone during the webinar mentioned, just thinking about walkability. People tend to, a lot of times people tend to look at their local neighborhood, and if I have to walk more than a couple minutes, it's just too far. And they said, well, think about when you go to the mall, and how. When you park your car at the mall, how far do you walk to get to the mall and then walking around the mall? I don't know how many of us still shop at malls. they're not the place they used to be in terms of popularity, but still, think about where you go, and you're willing to walk a fair amount there. So try to think of your neighborhood walkability in those terms. That it you know, well, if it's not 1 block away, it's too far for me. Well, that's where you think, well, yeah, we do.
But
Depending on where we go, we tolerate much more walking.
and that's a good point. But
The
there's
big
also,
box,
yeah, there's
big
also the
box
thing that
stores. Forget malls, the big box stores.
Yeah, same thing.
I spend upwards, I don't know, a third to a half a mile when we go through a big box store from, like you said.
that said, there is also the perception difference between, even if you are used to walking malls, even half that distance, if you're walking by house, and then the far end is the business that you're trying to go to, and that's the only business along the way, there's a much different perception difference between house, maybe 2-3 houses, and then a string of businesses, but the place you're going to is the far end. There's a lot different in perception on what you can actually achieve by walking that way.
Yeah, and then when you're thinking, going back to the complete neighborhoods topic that we discussed at the webinar last week, that thinking was more focused on multifamily units. I mean, if you think about walkability in a neighborhood of single-family residential homes, it's different in a lot of ways, and some of the concepts don't really translate very well to a single-family home neighborhood, which is most of Grafton.
Yeah. Mara's been trying to get in around me and you.
Yeah. So I have a lot of thoughts actually about this because I've actually taken the A and the B. So I actually know the route of the bus. It just goes right along Providence Road. And I think that there's actually a lot of space along Farnhamsville or within Farnhamsville or even like along Route 122A where the bus goes that could fit or that could potentially do or be a MBTA zone. And I know I've even walked around that area a lot, and it's too bad there aren't better sidewalks all along 122. I know a little bit of it's getting fixed up on the other side, but the B goes all along that route, and so there's a lot of, I think, ability to build up that area to be walkable alongside having multifamily homes.
Yeah, so I think this is a sort of conversation that we can really get going and keep going to use our imagination a little bit and put all of our heads together and we can continue to work towards identifying potential places in Grafton that could benefit from this zoning. And as I said, it doesn't have to be all in one place. We could say we could find 10 acres in this neighborhood, 25 acres in that neighborhood, something along those lines. We've got a lot of flexibility.
Yeah. Just in general, I kind of feel like there should be a bus station along at this junction of 122A and 122.
Mm-hmm.
Because the buses already connect right there. And then there's that new park that just got built somewhere down along that street. I feel like a bus could easily park in there and pick people up. There's a lot of housing in that area too. Yeah. But I don't know how we could go around that.
I definitely think that at least, from the perspective of improving the WRTA process, so if we see the overlay in Grafton that, Chris mentioned is looking to at least provide for us at an upcoming meeting, it can give us an opportunity, even if it doesn't directly feed into MBTA zoning decisions for us, it could still say, this might be a good spot, and we can put forward a recommendation, possibly with the select boards or someone else's additional support to the WRTA to say, here's some demographics of the area, this is what we think might be a good spot.
And some of what we've talked about, we don't need to limit our thinking to specifically the MBTA zone. We've got a master plan process in the works.
Yes.
And much of what we talked about, I think, would be worth including in the master plan thinking and consideration of alternatives and consideration what we might propose. I was hoping that we could fully integrate the MBTA zone into the master planning process. But I'm not quite sure that the timing works. In terms of one of the things that may come out of the master plan process is a recommendation to spend a couple of years in a more detailed, zoning realignment study, some a fairly comprehensive look at how we can tweak the zoning to, facilitate or incentivize development more along the lines we might end up deciding Grafton wants in the future. But that whole process could very possibly extend beyond December 2024, which is when we have to have our MBTA zoning in place. So to the extent that we can, I'd like to integrate the thinking of the MBTA zoning in with the master planning, but I don't think it's going to be 100%.
Prabhu?
I just spotted an area we might want to look at. The old mill, Barnumsville? No.
Yeah, Barnumsville is what.
No.
The Wisconut Mill? The one old mill that's still standing?
No, the one in on the west end that once had the great chimney.
Oh, the
was
Saunders
saved
Mill.
after the mill was torn down.
Yeah,
it has
Saunders.
the breached dam.
Yeah.
There's a fair chunk of land there that's not being used very well, as far as I can tell, and that does fit some of these. It has businesses, a relatively dense population, some businesses, opportunity for more, but that might be worth looking at as a possibility.
Yeah, that's the area I was thinking of around in there. So I've taken the maps around in there, and I think it could use development.
Mm-hmm. Yeah, there's some issues with what is the land like and whatnot, but certainly worth looking at, I would say.
Yeah, you can always tell by looking at a map whether the land is actually suitable for development.
Right.
But that's where you start. You look on the map. You look at where where it looks like there might be possibilities, and you dig a little deeper and find out if it's really workable. I think Prabhu has handed it.
Yes. I tried to acknowledge him,
Yes.
but go ahead, Prabhu.
I had one question. What is the feasibility of actually moving the MBTA station itself? Could that even be considered?
What do you want?
Moving the MBTA station?
Moving it.
Station?
Yeah, relocating
I
that
don't know.
location.
I don't know what station we're talking
For
about.
the MBTA, the
There's
train.
only one MBTA
Oh, the train station? Moving?
Yeah.
Not a chance in hell.
Yeah.
No?
You know what it took to build that?
Yeah.
And you know what it took to find a place to put it? And you know how much trouble they had to go through to shoehorn it in there?
I can tell you something about that, since I was involved in the planning for that MBTA commuter rail extension. It was an interesting challenge. The project altogether was extending the commuter rail from Framingham out to Worcester. And of course, Framingham had a station, Worcester had Union Station. It was the stations in between that we had to find locations for. My involvement was the environmental review of that project. But we spent a lot of time talking about different locations. In Grafton, there were basically the first location they looked at in Grafton was the old train station, which was
North Grafton.
Yeah, in North Grafton, Westboro Road, I think, or very close to Route 140. The problem with that location, I don't know if the station building was still there at that point in the late 80s, but the problem with that location was there was no place to park. Because that station, when it was in operation, most people walked to the train station. So parking was never a concern. But nowadays, in the modern times, people are driving their cars to the train station. So there really was only one suitable location in Grafton. And fortunately, it was right there and located as essentially part of Suntech Park, which we had targeted for industrial development. So it was it was a convenient location, and actually in Grafton, Grafton was the least controversial town for locating the stations. There were more fights in Westboro before it finally ended up where it was. Millbury just kicked it out entirely. Millbury was so against it that they gave up on even having a station in Millbury. Southborough, I think they had a couple locations under consideration before they finally arrived at that. And then Ashland had the same problem. They had several locations they tried before they found one that the community would accept. But yeah, I don't see it being at all likelihood that the MBTA would even contemplate relocating the station.
They might put the money into having proper trains that, you know, function correctly, rather than moving a perfectly fine train station.
Fair enough. Worth asking a question.
Yeah, well,
Great ideas come from.
Right. It's a question that's worth asking, even if the answer is, well, no, it's not practical. But it's worth at least asking the question.
Yes.
Because if you don't ask the question, you don't know the answer.
Mm-hmm. Okay, well.
Yeah, but I had another question.
Go ahead.
Chris, so I know that Shrewsbury is included as an MBTA community because of the Grafton station, but technically it's Grafton station. So how are they dealing with the MBTA situation? How are
They have buses.
they putting it?
So
They have buses.
Yep, they have buses. They're designated as an adjacent community as well.
Oh, sure.
So I'm not sure where they're targeting for zoning, but
I was just wondering if we could put it all together, because I know that the border is partially impeding our ability to put the contiguous zone together.
Yeah, that's a good idea, because they have a fair chunk of land in that UPS proposal or plan, that's, you know, part of the same parcel, really.
Yeah, I was wondering if we could work together.
Hmm?
Yeah, I was wondering if we could work together, but I don't know.
You might get 100 acres out of that, 50 for them and 50 for us.
Yeah.
Or 100 for the two of us together.
Yeah.
Yes.
When are we gonna actually have the official final rules?
The MBTA rules,
Yes.
the ones they came out with are described as the final guidelines.
Yeah. So why do we still have to have all sorts of training and discussion?
It's this 9-week webinar series from Mass Housing Partnership is for the purpose of helping communities figure out how they're going to comply with the rules, not what the rules are. The rules are pretty final, but I think there are some aspects of the rules that probably still need to be clarified. But you know, the series of webinars is all about, well, okay, now we know what the rules are. How in the heck are we going to comply with these rules? You know, what can we do? You know, the topic for this week's webinar is water and wastewater considerations, which is likely to have something to do with to what extent do we need, when we create our zone, to what extent do we need to take into account the capacity of our water and wastewater systems? And how do we deal with questions about that? So
Yeah.
next week, one or both of Chris and I will be able to report on that.
Yeah.
If
The
you
rules
want
are
to
final. The
develop
definitions are
50
not.
acres at 16 units, there's going to have to be new water anyway, and new waste handling.
Yeah, just to briefly circle back, I will say that once we have an idea on what we want to do, if we have an idea what would work, at least for our side of where the UPS, parcel is, we could certainly reach out with a letter to the Shrewsbury, planning board, and propose either them come to us or us go to them to discuss, what our idea is. Would they be, would they want to make, that section of their parcel similar, to align it so that a single person, or a single developer could come and develop the entire property in a suitable manner. But that's just one of our many options.
Well, it doesn't have to be a single developer. It just has to be zoned so that
Well, certainly.
one or more businesses could come in and try to develop portions of it.
Exactly.
But it'd be interesting to have some dialogue. I don't know whether Chris gets to talk to the folks up there too much, but probably he can. And
Chris probably knows somebody there because he before Chris came here, as you know, Chris worked in Shrewsbury.
yeah, well, yeah. So there might be
I certainly
someone,
have their contact information, so.
And Shrewsbury's town
know where they
manager.
live.
Shrewsbury's town manager was Grafton's assistant town administrator for a while.
Yes.
So we know
Yeah.
people there.
And before that, their town manager was had been our town manager for a
Yep.
long time. Our first town manager.
Yep.
Wait,
yeah.
we're a training ground for town managers.
Anyway, have we discussed the MBTA zoning to the extent that we wish to tonight? I see Chris has a hand
Yes.
for more.
I'll be real quick. Just I just wanted to circle back a little bit to the what Dave was discussing in terms of the parking and shopping malls and that walkability, and it just triggered the concept that I've looked at in my time in Shrewsbury. We were looking at the downtown there and creating what's been called a park once environment. The idea being that you have a public parking that you can go to, and then you go to your various multiple shopping locations. I think a lot of those are done through more design elements that we could put together some something like design guidelines that then we recommend for development under the MBTA zoning, that they try to use those elements. And I'm not sure how this would fit, if DHCD would turn their nose up, but there's an example, I believe it's Colleyville, Texas, that has design guidelines, and the buy right option is if a developer shows that they comply with, and I don't remember the numbers, but say 10 of the 20 design guideline criteria, they're allowed to develop the project by right. Otherwise, it would be by special permit. So I'm not sure if that would still be eligible, something like that, to require, create a list of guidelines that a developer can choose from that fit their own project. But that's something that maybe we can kind of look at, and I can try to get some a temperature on DHCD if that's something they would be willing to entertain, or if that would then exclude our zone from compliance. But
It'd be good to
Sounds
know
like a good idea.
Yep.
Yep.
Make it so.
All right.
So we beat this to death for tonight.
I think we have. All right, so we have no bills, and then minutes of previous meetings. We do have one set of minutes for August 8th, 2022. Do I have
Move
a
that
motion?
we approve. Did something happen here with? Oh,
I
no.
hear you.
Move that we.
I said I hear you.
Yeah, no, it's something. Join new meeting came up.
Uh-oh. I think Bob clicked join new meeting.
I'm back, I think.
Yes,
Um,
you are.
Whatever it's worth. Can I, unless somebody's done it, can I move to approve the minutes with any edits that we discuss at this time?
I have a motion. Do I have a second?
Second.
I have a motion and a second to approve the minutes with any changes made in discussion. Is there any discussion? Hearing none. Mr. Robbins. Oh, go ahead. Sorry.
Just I hadn't had a chance to review minutes at a time. That I will pick one nit under discussion items B, fall town meeting warrants and schedules. On the parking zoning amendment, I think Mr. McGoldrick was referring to the Historic District Commission there, as opposed to the Historic Commission, which is also a town body.
Isn't it the historic district?
Yes.
Sure.
Yep. The minutes say Historic Commission, and I think it should refer to the Historic District Commission.
I'd agree. Any further discussion? Hearing none. Mr. Robbins.
Aye.
Mr. Hassinger.
Aye.
Ms. Hassinger.
Aye.
Mr. Venkatraman.
Aye.
And I vote aye. I declare the motion carried unanimously. We have approved the minutes. Staff report.
Thank you. I have a couple items I just wanted to kind of bring your attention to. I'll run through quickly. So as part of the CMRPC ongoing 2050 visioning session, they did hold an infrastructure summit. Unfortunately, I had other items that I had to attend to, but I was able to attend for a brief portion of that summit and give a show of support from Grafton. The discussion was worthwhile, and CMRPC is going to send me the slides, and they will be following up for one-on-one interviews with the communities, so we'll have another opportunity to coordinate with staff and make sure that we have all of our infrastructure needs included in that 2050 report. I also attended the Capital Summit with staff, looking at our capital budget, and went through those items. Looking at in the next couple of years, the master plan is the big budget item that the planning department has on that list. I also had a proponent from Westboro for the Boston-Worcester Airline Trail reach out to me. So that's actually primarily in Shrewsbury through Westboro, but they brought my attention to there is a somewhat of a planned, I guess you could call it a spur to the B-Walt that actually goes essentially through the Tufts campus connecting to the MBTA station. And then up through Westboro to the Boston-Worcester Airline Trail, which is conceptual. It's not actually completed at this time. But that's something that, especially with the MBTA zoning and all of these questions going on, that there might be some renewed interest in complete streets. There might be some renewed interest and opportunity to kind of further develop or at least conceptually plan that B-Walt spur. There's also been a little bit of a reinvigoration of the Blackstone bike corridor. So those two items I think are things that we can try to make some progress on. Again, the Blackstone corridor is has had a lot of conceptual design. There's obviously challenges with the actual implementation of it. Would require a lot of takings, but certainly something that I think we can try to continue to push some of those bikeways and amenities, especially with new development opportunities coming to town. In addition, there's the Grafton Science Park. The Economic Development Commission is looking to, and Economic Development Coordinator has been working to generate renewed interest, working with Tufts and Mass Development in order to kind of hopefully see some more projects and development and interest in that area. We'll be holding a luncheon near the end of October, having a number of really targeting biomedical uses, but having some of the big players in that area to come out and take a look at Grafton and see if there's we can put together some interest in that site. And then lastly, I did have a discussion with CMRPC regarding the status of our master plan just this afternoon. And they will be coming to our October 24th meeting in order to provide an update. They've largely collected a lot of the data that's needed. There's a couple other items that they have that they're going to send over a list of questions and kind of data collection points that I'll be circulating to the departments and boards as relevant prior to that meeting. So hopefully we'll have some update on that. And the idea being after they've responded to that, largely follow up from that question, and those data points would then be handled in the second phase, which is the stakeholder engagement. But at least we'll get a little bit of a preliminary feedback to start those stakeholder discussions, and hopefully knock off some of the low-hanging fruit questions for that. So, but exciting to see them coming to us for the October 24th meeting. So, and that's all I had.
All right. Our next agenda item is correspondence. Does anyone want to discuss anything in the correspondence?
Remind me, what, I don't remember whether did our correspondence get the cease and desist
Yes.
Yeah.
order for Holden?
Yes.
It
Yes.
did.
It's there.
Yes, it did.
Again, I'm interested in what we're going to do about that, or what's going to happen about that. I would really like to see the Board of Selectmen ask us to develop a zoning solution. I don't think, no one's asked us to do anything there, but the answer, and I think there's some agreement, if you want to know about it, that the ultimate answer there can only be to fix the zoning. And fixing the zoning is maybe a little tricky, but it would be better for us, with the support of the select board, to develop a proposal than it would be for petitioners, citizens petitioners, to submit something. I don't remember the last time that a citizen written zoning article passed. I don't remember very many that there have been. The last one was in South Grafton for the mill to do cannabis, if you remember, and that did not fare well. And I don't know when the next one back from that was. So
I'll say I would be more than happy to if the proponents of making some change, outside of select board even, has a thought on what they want to do. I would be more than happy to host them as the planning board here, and we can discuss that with them as well before it even gets to a citizen petition for town meeting.
well, you could even just have folks come in under public input and say,
Yes.
"Hey, planning board, there's this problem. We need your help."
No, public input is definitely an option, but I want to steer away from having a discussion on a public input item that is not on our agenda.
Right. Well, you don't get discussion, but within limits.
Yeah.
But
Yeah.
that
I think-
gives us a start on putting it on our plate as
Yeah.
something we may want to take up since we've been asked.
Right. If the board on its own initiative would like to pursue the topic, I think we could put it on a future meeting agenda. I know I have some thoughts about what we might do in zoning to address the situation. I've not tried to discuss them widely with a lot of people because it's not clear that there's a desire for that. But if the board would like to sort of proactively proceed on this, then we can at least talk about what the possibilities are, what approaches we might think could be workable. And we could just sit back and wait for the Holdens to try to come to us asking for help, or we could be more proactive.
Well, my point is, it'd be nice if the select board were involved in or even the town administrator asking us to get going on it, because you got to have a happy situation when you get to the town meeting.
Yep.
When we take this up, I'm going to have the question though. There's another use that's being conducted there that is not allowed under the zoning, and there seems to be disagreement about how non-compliant it is. That is, the current complaint involves commercial entertainment, but there's also selling of alcohol. Some people seem to think that a one-day license from the select board trumps the zoning. And what they really need is, in any case, is zoning that allows them to actually have a full-fledged license, so they don't get into the 31-day license issue. And so there will be that question to be explored so that we can shape something that fits.
Yeah, I'll say
Okay.
from my standpoint, in regards to the idea of being proactive, like generally I would love us to be proactive and try to come up with ideas, but I would also say ultimately if the Holdens themselves or the town administrator or select board, or, if no one is asking for a zoning change, if the Holdens say, well, we don't want to go through any further effort on this, we're just not going to do this type of process. If that's what they ultimately decide, we're kind of putting a cart before the horse, so to speak. I also on the same token, I'm conflicted because I would also not want them to come to us have had zero discussion, so we're all over the place, and it gets a confusing outcome.
Yeah, so I think it would be helpful for us to know that there is some interest on somebody's part besides ourselves. There is some interest in seeing some zoning work being at least considered here, to whatever end. Because, yeah, if for example the Holdens decide, well, we're just not going to do this anymore, then it's a non-issue for us. Except that it could come back at some point in the future.
Yep.
But if the Holdens have any interest in continuing this, they've made it fairly clear that without the ability to sell alcohol, it's not really a viable business, that aspect of it. So if they have a desire to at least look for zoning alternatives that could possibly facilitate their business, then if we know that they're interested in it, then, and particularly if we get some additional support from the town administrator and the select board all saying, yeah, could you guys please look into this? We'd like to find a solution here. Then I think that gives us a reason to continue the discussion.
I would agree.
I had a few words back and forth by email with the town administrator, and I think he at that point anyway was agreeing with me that the eventual solution has to be zoning.
Yeah.
So if say Chris talked to him, I'd like to get the ball rolling.
Yeah, I think one way or another, the zoning would have to allow a use through which they could then apply for a pouring license.
Yeah, well, I think what you do is, how you have one idea. You have in the zoning 2 lines, one for agriculture over 5 acres and another for agriculture under 5 acres, isn't it?
Yes.
So as to recognize, in that case, the agricultural exemption. You could have, you could either do a special overlay zone landing on them, allowing what they need, or you could have a line, you could have 2 lines under alcohol and under entertainment, one for, over 20 acres and under 20 acres, or something of that sort. Begin to work around either of those approaches. What you don't want to do is just open up alcohol or commercial entertainment in R40. That is not going to pass.
No, that I would not recommend that approach. I also would not recommend an approach of rezoning that particular parcel of land to say neighborhood business or community business where, these kinds of activities are allowed. I think it's best to keep that zoned residential with the agriculture exemption applying. But the thought I had on this was, not to dig into it too deeply, but to define these additional activities, call it agritourism for one of the more commonly used terms these days, but to define that as an accessory use, accessory specifically to an otherwise exempt agriculturally. So connected to the agriculture use, but sort of define, here are some additional things you can do as accessories to an agricultural use. And you'd have to define the parameters. Like you'd want to make sure that it's relative to the agricultural use, the accessory uses, the agritourism accessory uses would be some small fraction of the total use, however you want to define that. And there's a lot of details that would have to be worked out, but to conceptualize it in terms of zoning as an accessory use, accessory specifically to an otherwise exempt agriculture use, would sort of it would give some flexibility to this location, conceivably to other locations. It would apply to any agriculture use with probably some minimum size. I haven't tried to work out a lot of the details, but conceptually defining it as an accessory use rather than a principal use could turn out to be a workable approach. I remember looking up, sort of briefly doing a little bit of digging on agritourism zoning in general, and I think that the concept of that as an accessory use has come up in some other locations.
I did some poking around with the people who know about what's going on with agritourism, like up at CMRPC and around there, and no one's heard of, so far I haven't found anyone who's heard of any places doing this kind of thing, like a beer garden. There are rather milder, more heavily agriculturally oriented projects. So, that's why you have to work on a definition.
I
do think that you have to do something like on over 20 acres or whatever, because you say, as soon as you put this down, as soon as you pass this thing, someone with enough acres to qualify, 5 acres, put in some plants and open a beer garden, or whatever it is. You got to be careful to not spot zone and yet at the same time get the job done the way that would be satisfactory.
Yep, that's the sort of thing that whatever approach we take, that's absolutely that's the type of thing we have to think about.
Exactly. Yeah. That's why we need to get going.
Yeah. So we've got some ideas that we can work with.
Yeah.
We sort of, I think we're saying we would like to be asked to work on it, or at least informed whether it would be worth our while to even follow up on any of these ideas. Is there an appetite for doing something by way of zoning? And I think you're absolutely right, Bob. I don't think there's any way to accomplish what they would need without zoning. It's got to be something that we do in zoning, however we approach it.
Yeah.
Okay.
We've got at least a couple of ideas floating here, which is cool.
I think we've killed that one.
For now,
I would agree. And I'll just give Chris the direction that if any people we mentioned come to you to say they want to have this talked about or come before us, whatever, just you can add it to the agenda for the next available meeting that makes sense.
Absolutely.
All right.
Yep. Seems like we're willing to work on some of the ideas we've already brought up here. Just give us a reason to work on it.
How about reports from planning board representatives?
You want to get out of here, don't you, Bob? I was about to go there.
Yeah, we'll eventually have dinner. Maybe.
So any reports from planning board representatives on town committees and CMRPC.
I think I've already reported my little bit.
So
I haven't been able to attend my first EDC meeting. I think I'm going to be attending that on the 29th. That would be my first one.
thank you.
I have nothing to report from the committee on which I am the board's representative.
And I've talked all about the CPC items that we've had. So
I move we adjourn.
Second.
I have a motion and a second to adjourn. This is not debatable. Mr. Robbins,
Aye.
Mr. Hassinger,
Aye.
Ms. Hassinger,
Aye.
Mr. Venkatraman,
Aye.
and I vote aye. I declare this meeting of the Grafton Planning Board adjourned.